Hello everyone. Today we will be understanding cognizable offense and non-cognizable offense. So cognizable offenses are those offenses which are very serious in nature. For example, murder, rape, theft, robbery, kidnapping, etc. And non-cognizable offenses are those offenses which are less serious in nature. For example, defamation, simple hurt, public nuisance, then criminal intimidation. These are known as non-cognizable offenses. So cognizable offense is defined in section 2G of BNSS and non-cognizable offense is defined in section 2O of BNSS. We'll see the definition from the Bear Act. Cognizable offense, for cognizable offense we file FIR, which is known as first information report, and we file it under section 173 subsection 1 of BNSS. And for non-cognizable offense we file NCR, it is known as non-cognizable report, and we file it under section 174 subsection 1 of BNSS. In cognizable offense, the police officer does not need any warrant to arrest any person, and neither they need any order from the magistrate to start the investigation. But in cases of cognizable of non-cognizable offense, they need warrant from the magistrate to arrest any person, and also to start the investigation they has to take permission from the magistrate. Now if we see the definition, uh, Section 2G, definition of cognizable offense, it says cognizable offense means an offense for which, and non-cognizable case means a case in which. So here, that in the definition they're using two different terms, cognizable offense and cognizable case. So what does this mean? Are they using separately two terms? So does that mean that this both these terms are different, cognizable offense and non-cognizable case? So if we see cognizable offense, they use cognizable offense for single offense. Where is it written? It is not written anywhere, it's the interpretation. And cognizable case is group of offense, or multiple offense, more than one offense. If you read section 174 subsection 4 of BNSS, it says, subsection 4 says, where a case relates to two or more offense of which at least one is cognizable, the case shall be deemed to be a cognizable case, notwithstanding that the other offenses are non-cognizable. So from here we can interpret, here also we can interpret that where two or more offenses are there, then it will be termed as cognizable or cognizable case. It's not telling about cognizable offense. So that's why if we are using cognizable offense, it means that we are talking about a single offense, and if we are using cognizable case, it means we are talking about a group of offense. And if we see the provision subsection 4, what it says, when a case relates to two or more offense of which at least one is cognizable, the case shall be deemed to be a cognizable case, notwithstanding that the other offenses are non-cognizable. So what this provision is telling, subsection 4, it is telling that if there are more than one offense of which at least one offense is cognizable, then that offense will be called as cognizable case. So for example, if there is a offense A, offense B, offense C, offense D, and offense E. So there are five offenses, of which A is a non-cognizable offense, B is non-cognizable, C is non-cognizable, D is non-cognizable, and E is cognizable. So in this case, what type of case it will be? It will be a cognizable case, because the provision says that at least if from all the offenses, more than, if there are more than one offenses and from them at least one is cognizable, then the whole case becomes cognizable case. So that's why generally if you go to the police station, for example you go to the police station with 10 non-cognizable case, then the police tries to attach at least one cognizable case, because if they can attach one cognizable case, or they can find one cognizable case from the 10 of the cases, then the whole case becomes a cognizable case. And we know that in cognizable offenses or cognizable case, no arrest, arrest is not arrest is arrest can be done without the permission of the magistrate, and even we can start the investigation without the permission of magistrate. So police officer does not need to take permission from the magistrate. So that's why police officer generally they tries that you go with how many, however how many offenses you go to the police station. If it is a non-cognizable case, they try to attach at least one cognizable case so that it becomes a cognizable case, and they can start the investigation and arrest without the permission of the magistrate. So if we continue with the definition, it says a cognizable offense means an offense for which, and a cognizable case means a case in which police officer may, in accordance with the first schedule or under any other law for the time being enforce arrest without warrant. So what it is telling, in accordance with the first schedule, it means in accordance with the first schedule means in if you see the first schedule, there all the list of the cases are there, means what type of offense you have committed, whether it's a cognizable offense or non-cognizable offense. So from there you can understand. If okay, we'll see the first schedule. Yes, so first schedule is in page number 231 of commercials bear act. First schedule, all everything is written here. Here the sections are written of a BNS, then offense, what offense you have committed, the punishment, how much punishment will be given to you, then whether it's a cognizable case or a non-cognizable case, bailable or not non-bailable, by which court it will be trialable. Everything is written in this first schedule. All the offenses that are there in the BNS, Bharatiya Nyaya Sanhita, all those offenses are there in this first schedule, and everything, whether it's cognizable, the term of punishment, which court it will be trialable, everything is written in this schedule. So from if you go through the first schedule, you will be able to understand whether it's a cognizable or non-cognizable. So it is telling a police officer may, in accordance with the first schedule or under any other law. Any other law means it is talking about the other laws that are there, for example NDPS act, then NI act, and POXO act. In those cases also, if it is a cognizable case, then the police officer may arrest without warrant. Police officer does not need the permission of the magistrate to take to arrest. So the power of arresting, the power to arrest without warrant, we are getting from section 2G of BNSS. So if police officer goes to arrest someone, then the police officer can say that you have, since you have committed a cognizable offense, I have the power to arrest you without warrant. Generally people says na that while police comes to arrest, they say that show me the warrant to arrest. So if it's a cognizable case, then no permission of magistrate is required, no warrant is required. But in case of non-cognizable offense, it is saying that non-cognizable offense means an offense for which, and non-cognizable case means a case in which a police officer has no authority to arrest without warrant. So in non-cognizable case, you cannot arrest without warrant, no arrest without warrant, section 2O of BNSS. So here the citizens are getting the right, the person who is the accused, he is getting the right, he can tell the police officer that show me the warrant before you arrest me, because I have committed a cognizable non-cognizable offense, so you need to get a warrant from the magistrate to arrest me. The accused can refuse to get arrested by the police officer. Okay, so for arrest, we understood that the permission is given in section 2G of BNSS, but where is the permission of investigation from the magistrate given? The permission is given in section 175 subsection 1 of BNSS. It is telling that, if we see section 175 subsection 1 says that any officer in charge of a police station may, without the order of magistrate, investigate any cognizable case which a court having jurisdiction over the local area within the limits of such station would have power to inquire into or try under the provisions of chapter 14. So chapter 14 is basically talking about the jurisdiction of criminal courts to conduct inquiry and trial. So it is telling that if any police officer, any officer in charge of a police station, who is the officer in charge of a police station? SHO, station house officer. So if any officer in charge of a police station may without the order of magistrate investigate any cognizable case which a court having jurisdiction over the local area. Okay, so it is telling that police officer can conduct the Section 175 subsection 1 is giving power to the police. It is giving power to the police that they can conduct investigation without the order of the magistrate if it's a cognizable case. And in non-cognizable case, we get the permission from section 174 subsection 3. Subsection 3 gives us the permission, but where it is said that the permission is required, subsection 2 says that section 174 subsection 2 talks about the permission, that we need permission. It is not giving permission, but it is talking that we need permission. If we read subsection 2, no police officer shall investigate a non-cognizable case without the order of a magistrate having power to try such case or commit the case for trial. So it is telling that police officer, to conduct investigation of a non-cognizable case, they need the power, they need permission from the magistrate. And subsection 3 gives the order, gives the power to conduct that investigation. It says any police officer, subsection 3, any police officer receiving such order may exercise the same power in respect of the investigation, except the power to arrest without warrant, as an officer in charge of a police station may exercise in a cognizable case. So what it is telling? Subsection 2 is telling that power permission is required, but subsection 3 is telling if the permission is given, then in that case the police officer will be having the same power as they have in case of cognizable case, except the power to arrest without warrant. They will be having the same power as they have in cognizable case. So you have seen that in section 175 subsection 1 the power is given to conduct investigation of cognizable case. So from 174 subsection 3 we come directly to 175 subsection 1. The power is the same, just that you need the permission from the magistrate. So if we see, अगर हम देखें in criminal cases offenses of two type. एक होता है cognizable offense, दूसरा होता है नॉन कॉग्निजेबल ऑफेंस. सो कॉग्निजेबल ऑफेंस में हमने क्या देखा कि रजिस्टर्ड कॉग्निजेबल ऑफेंस किस सेक्शन में रजिस्टर होता है? सेक्शन 173 सबसेक्शन 1 में हम कॉग्निजेबल ऑफेंस को रजिस्टर करते हैं. बट नॉन कॉग्निजेबल ऑफेंस वी रजिस्टर अंडर सेक्शन 174 सबसेक्शन 1. अब हमने रजिस्टर कर लिया, अब हमें इन्वेस्टिगेशन करना पड़ेगा. तो इन्वेस्टिगेशन का पावर कौन देता है इन कॉग्निजेबल केसेस में? Section 175 subsection 1 gives the power to the police officer. Police officer gets the power from subsection 1 of 175 कि police officer investigation कर सकते हैं without the order of the magistrate. But in case of non-cognizable offense police officer को permission लेनी पड़ती है. 174 subsection 3 में परमिशन मिलता है पुलिस ऑफिसर को कि आप नॉन कॉग्निजेबल ऑफेंस की इन्वेस्टिगेशन कर सकते हो. और इफ़ यू आर स्टार्टिंग द इन्वेस्टिगेशन ऑफ नॉन कॉग्निजेबल ऑफेंस यू विल बी हैविंग द सेम पावर दैट यू हैव इन केस ऑफ कॉग्निजेबल ऑफेंस. तो जब आपको मिल जाता है पावर यहाँ पे 174 में जब आपको परमिशन मिल जाता है तो ये 174 ये भी कह रहा है कि आपको सेम पावर होगा जैसा कि कॉग्निजेबल केसेस में पावर होता है. तो बेसिकली नॉन कॉग्निजेबल ऑफेंस की भी पावर, मतलब वी आर कमिंग टू द सेम थिंग. नॉन कॉग्निजेबल, जस्ट दैट नॉन कॉग्निजेबल ऑफेंस हमें परमिशन की ज़रूरत है. नॉन कॉग्निजेबल ऑफेंस में एक बार परमिशन मिल गया फिर द पावर बिकम्स द सेम. अब यहाँ से इसके बाद प्रोसीजर स्टार्ट होता है. प्रोसीजर स्टार्ट्स फ्रॉम सेक्शन 176. अब 176 में प्रोसीजर स्टार्ट होगा एंड द प्रोसीजर विल बी, अच्छा कॉग्निजेबल ऑफेंस और नॉन कॉग्निजेबल ऑफेंस दोनों का प्रोसीजर सेम होगा कि अलग होगा? क्योंकि यहाँ पे तो हम पावर की बात करें, पावर सेम होगा. मैजिस्ट्रेट, सबसे पहले मैजिस्ट्रेट से परमिशन लेनी पड़ेगी. एक बार परमिशन मैजिस्ट्रेट से मिल गया नॉन कॉग्निजेबल केस में फिर पावर बिकम्स द सेम जैसा कि कॉग्निजेबल केसेस में होता है. दैट इज अंडर सेक्शन 175 सबसेक्शन 1. एंड कॉग्निजेबल केसेस में तो 175 सबसेक्शन 1 में ही हमें पावर मिल रहा है कि वी कैन कंडक्ट इन्वेस्टिगेशन. अब प्रोसीजर ऑफ इन्वेस्टिगेशन वो कैसे, वो सेक्शन 176 में दिया हुआ है. तो प्रोसीजर दोनों का सेम होगा कि डिफरेंट होगा? तो ये हमें 176 अगर हम पढ़ेंगे BNS का तो हम देखेंगे प्रोसीजर फॉर इन्वेस्टिगेशन. इट इज़ टेलिंग दैट इफ फ्रॉम द इंफॉर्मेशन रिसीव्ड और अदरवाइज An officer in charge of a police station has reason to suspect that the commission of an offense which he is empowered under section 175 to investigate. So पावर कहाँ से मिल रहा है, which he is empowered under section 175। और यहाँ पे एन ऑफेंस की बात कर रहे हैं, यहाँ पे कोई कॉग्निजेबल ऑफेंस या नॉन कॉग्निजेबल ऑफेंस की बातें नहीं हो रही है, यहाँ पे एन ऑफेंस की बात हो रहा है। मतलब इसमें कॉग्निजेबल ऑफेंस भी आ जाता है, नॉन कॉग्निजेबल ऑफेंस भी आ जाता है। दिस इज द इंटरप्रिटेशन ऑफ एन ऑफेंस। और इसको पावर मिल रहा है सेक्शन 175 से कि हम इन्वेस्टिगेशन कर सकते हैं, प्रोसीजर ऑफ इन्वेस्टिगेशन। सो बेसिकली जब हमें पावर 175 से मिल रहा है और कॉग्निजेबल ऑफेंस बोल रहा है कि तुम्हारे पास सेम पावर होगा जैसे कि कॉग्निजेबल केसेस में है, तो इन्वेस्टिगेशन का प्रोसीजर भी सेम ही होगा, क्योंकि हमें परमिशन, पावर, प्रोसीजर, इन्वेस्टिगेशन का प्रोसीजर स्टार्ट करने का पावर कहाँ से मिल रहा है, 175 से ही मिल रहा है, और प्रोसीजर 176 में दिया हुआ है। तो बेसिकली नॉन कॉग्निजेबल ऑफेंस में भी द प्रोसीजर विल बी सेम, जस्ट दैट यू हैव टू टेक परमिशन। आपको मैजिस्ट्रेट से परमिशन लेना पड़ता है बिफोर स्टार्टिंग द प्रोसीजर। बाकी एवरीथिंग इज सेम, पावर भी सेम है, प्रोसीजर भी सेम है, इतना ही है। तो आई थिंक आपको आज का लेक्चर समझ में आ गया होगा। ये जो मैंने पढ़ाया है ये बेसिकली मैं इन्वेस्टिगेशन के चैप्टर में पढ़ाता हूँ। इन्वेस्टिगेशन में मैं एक और लेक्चर लूँगा इन्वेस्टिगेशन, इंक्वायरी एंड ट्रायल पे, वो हम डिफरेंसेस समझेंगे। उसके बाद मैं इन्वेस्टिगेशन का चैप्टर स्टार्ट करने वाला हूँ। इन दैट चैप्टर ऑफ इन्वेस्टिगेशन फ्रॉम इट इज़ चैप्टर 13 173 से 196 तक है। वो मैं बहुत ही डिटेल में करने वाला हूँ। ईच एंड एवरी सिंगल पॉइंट जो भी जैसे भी मतलब प्रोसीजर होता है वो बहुत ही डिटेल में हम समझने वाले हैं, ईच एंड एवरी सिंगल पॉइंट। तो आप लोग, इट्स अ वेरी ग्रेट अपॉर्चुनिटी आप लोगों के लिए, बिकॉज इफ़ यू इतना डिटेल में, देर इज़ नो चैनल, नो यूट्यूब चैनल दैट एक्सप्लेन्स इन दिस डिटेल। सो अगर आप ये मैंने भी मतलब ये सब तो मैंने भी स्कूल में कभी सीखा नहीं है या फिर यूट्यूब चैनल में भी कभी नहीं सीखा है। ये बेसिकली आप बहुत ज़्यादा फीस दे के कोचिंग सेंटर्स में आपको पढ़ना पड़ता है ये सब। तो आप लोगों को भी अगर सीखना है तो यू कैन सब्सक्राइब मी, आई विल बी टीचिंग दिस at least 30 to 40 lectures I will be taking just on investigation, because it is the single most important chapter in this BNSS whole BNSS में। अगर किसी भी कॉम्पिटिटिव एग्जाम्स में कोई भी सवाल आता है, एक भी सवाल आता है, तो वो इन्वेस्टिगेशन के चैप्टर से ही आता है, और ये मैं बहुत ही डिटेल में करवाने वाला हूँ। सो आप लोग कीप वॉचिंग। चलो सब्सक्राइब भी कर लेना। अभी मिलते हैं नेक्स्ट क्लास में। बाय बाय एवरीवन।